Last week you were introduced to the core of intellectual property rights. As an individual and a student, copyright and fair use are probably the most familiar to you. I was just speaking with my nephew, who's 12 years old, about videos that he and his brother created. He mentioned he was able to incorporate other works into his work because of fair use. He didn't have all the details correct, but I thought it odd that a 12-year-old was invoking the fair use doctrine. In this module, you'll learn more about the requirements for something to be copyrighted, how works enter the public domain, what constitutes derivative work, as well as the first sale doctrine and idea-expression dichotomy. According to the United States Code, Chapter 17, Section 106, the person who owns the copyright to a work has the sole authority to do any of the following things with the work, or he or she can grant this right to someone else. They can sell the copyright in its entirety, they can license specific portions of the work, they can give any and all rights to another person or company. These rights include reproducing a work, which is the one you're probably most familiar with, copying, preparing derivative works, distributing the work by sale or rent, performing the work if it's a musical or theatrical work, and displaying the work if it's an art piece or a photograph. There's also another right that pertains only to sound recordings, and that is that the creator has the right to transmit the digital audio of the sound recording. Let's take a look at an example of this. The Phoenix Suns are the copyright owners of the Suns logo. They can sell the right to make jerseys with the Suns logo on them to ABC Company. This constitutes a limited license authorizing ABC Company to create the kind of jersey with the logo in a specific place and being sold in the quantity and location that the contract specifies. This effectively means that the Phoenix Suns can have their logo on all sorts of products. If the product doesn't sell, however, the Suns have not lost any money, as they sold the license to create the product to another company. The other company invested their time and money creating the product, distributing the product, marketing the product, as well as, of course, paying the Phoenix Suns for the right to use the logo. As you can see, it's very lucrative for a company that owns a valuable IP to earn money on the item without having to do very much. There are only three requirements for something to be copyrighted: fixation, originality, and minimal creativity. Your text calls this work of authorship. Okay. Works such as plays, books, artworks, films, computer programs, etc. can all be copyrighted if they meet the above three requirements. The first requirement is fixation. This simply means that a work has been frozen into a tangible medium. A song must be written down or recorded. If it's a play, it has to be written down. Okay. This seems obvious, but consider a dancer who creates a new dance. Generally, dancers do not write down their choreography. However, the dance movements and sequences are not copyright protected until they are either written down or video recorded with the dance in process. Fixation is a requirement. Um, Note that the person who writes a book on a computer and has a digital file of the book is considered to have the work in a tangible medium, even though it is digital. Originality means that the thing for which the copyright is sought must be original and not copied from any other work. It can, however, be similar to another work. Minimal creativity is sometimes the most confusing of these because people believe that something has to be literary or a work of art, but that's not true. The threshold to determine if something is required minimal creativity to create is quite low. A file with addresses in it does not possess enough creativity. However, somebody took the names and contact information for all of the members of a professional organization and arranged them onto a page in a unique manner. This might be considered to possess minimal creativity. Chapter 2 of McJohn gives you much more detail regarding what each of these categories of works include. Items in the public domain are available for anybody to use or copy or transform. The major way that things become public domain is that their copyright term expired. Works can get there if the copyright owner also didn't follow the rules for renewal. At some point in time, there was the option to renew, and the copyright owner had to do paperwork, pay a fee all before a certain date, and if they didn't do that, the item was no longer considered protected. The same is true of the existence of the copyright symbol. Okay, during a specific period, the copyright symbol had to appear on a work, or it was no longer protected by copyright. Another way something gets in the public domain that's not real common is a dedication. The copyright owner waives their ownership rights and dedicates the item to the public domain, thus making it available for anybody to use without asking permission. Okay. Federal employees also produce a lot of documents during the normal course of their duties. These are not protected generally by copyright. Okay. This only applies to federal workers, and there are some exceptions to it regarding logos, etc. Okay. Laws are also not copyright protected. There are things, however, that even if they do possess the three qualities that are required to be copyrighted, can never be copyrighted. Okay? Everybody is able to use these works freely as they are already in the public domain. According to STEM, which is one of your reading authors, an item can be in the public domain for several reasons. The first is the copyright on the item could have expired, or the owner of the copyright didn't follow the renewal rules. It could have been created and placed in the public domain by dedication. For example, somebody wrote a book and wanted everyone to have access to it, so they effectively gave the public their work to use freely. The work could have also been created during a time period in which a copyright notice was required. You know, that's that little C with the circle around it. Without the right copyright notice, the item would be considered public domain because it did not follow the rules. It also could obviously be a work that can't be copyrighted, such as a directory listing of names, such as the phone book. Also note that works created by a federal worker in the course of their duties cannot be copyrighted. Note that this is a federal worker, not a local worker, government worker, not a state worker. just a federal worker, those things are automatically considered public domain. Laws also are considered public domain. However, this is another one that you have to be careful with, because although laws cannot be copyrighted, they can be presented in a unique manner, and therefore the manner is what is copyrighted. This will make more sense when we talk about the idea-expression dichotomy. There are other things that can't be copyrighted. Circular 31 does a good job of exploring each of these categories, so make sure to take a look at it. It's important to remember copyright does not protect ideas. If I have an idea for a play about two men, one of whom is super neat and one who is super messy, and somebody writes a book about two men, one of whom is super neat and one who is super messy, they haven't infringed on my copyright, as all I had was an idea. Think about it another way. Consider ideas are not generally written down, which means they additionally do not meet the fixation requirement for copyright. Other things that aren't protected by copyright are methods and systems. I can't create a method of turning stones into gold and copyright the method. I can, however, probably patent the method if it meets the criteria for patenting, but it would not be protected by copyright. There are some things that can never be protected by copyright, and Circular 31 has a really good listing of these. Most of them are self-explanatory. There's a couple I want to talk about. The first is names of businesses and slogans. Those things cannot be copyright protected. But wait, you're thinking Nike's Just Do It. Nobody can use that without getting sued. Well, that is because slogans, names of businesses, names of products are trademark protected. And we will talk about that in Unit 6, but for right now, just know that it's not being protected by copyright. The other thing I want to talk about is listings of ingredients. And I'm going to give you an example on the next slide that I hope helps you understand it better. Listing of ingredients, such as the listing of ingredients for macaroni and cheese. 2 cups of milk, 2 cups of shells, 1 cup of white cheddar cheese is not able to be protected by copyright. However, the expression of the recipe, expression of the listing, is available to be protected by copyright. So, for example, at this URL, I found this recipe for shells and white cheddar. And the chef writes, in a medium saucepan, bring the milk and pasta to a simmer over medium heat. Cook for about 20 minutes, etc., etc. Okay. This is an expression of how this person makes macaroni and cheese, and therefore is not a mere listing of ingredients. Therefore, according to the idea-expression dichotomy, the expression, this recipe, is specifically protected by copyright. I know it's really confusing. There are some really good examples in McJohn, and we're going to keep talking about it. So let's take a look at this a little further. Ideas can't be copyrighted, but the expression of them can. So what does this look like? Suppose there's a story about a couple who secretly marry in the 1900s. One of them's Jewish, one is Irish Catholic. At the time that this was totally scandalous, totally uncommon, the fathers are both really upset, yelling, screaming, angry for years and years, at least until the babies are born, and then everything is fine. This is an idea for a story. This cannot be copyright protected. Let's get more specific. What if a play was written that follows that general idea, and it's called Abby's Irish Rose? Then another playwright comes along and writes a play about the same idea called The Coens and the Kellys. The names of the characters are different than in Abby's Irish Rose. The descriptions are different. The dialogue is different. The sub-events that happen are different. The Coens and the Kellys is not considered infringement on Abby's Irish Rose play. A basic storyline and stock characters cannot be copyright protected. Both of these are ideas. A stock character would be like the overbearing mother-in-law. Many movies and plays have a character such as this, but her exact name, age, specifics are different. What about the big scary man who comes on stage and everyone is immediately frightened until they find out he is a teddy bear at heart? Another stock character. If you have an overbearing mother-in-law named Joan and you describe her in a certain way and the words that come out of her mouth, either on paper or in the movie play, are different, then she can be copyrighted. The courts received many cases of supposed infringement when all that was really copied was the idea. Let's look at this. So Steinberg created this illustration for the New Yorker, and it shows how the people who live in New York view the world. Of course, Manhattan is the most important. It's the largest thing. It's rendered in extreme detail. Everything else is teeny in comparison because it's not important to Manhattanites. Okay. The other things on the horizon are there, but they're only generally drawn. They're not specific. Okay. So this illustration basically shows the worldview of New Yorkers to the rest of the world. Okay, all right, so let's look at this. And this is the poster for the movie Moscow on the Hudson, which is not related to me by any way. Okay, let's take a look at them together. Okay, so let's look at them together. Okay, they both have the red line for the horizon. They both have the blue to show water. They both use the same fonts for the title. Both show a section of New York in great detail, and the rest of the world is tiny. They both use the same type of line and paint wash. Okay. The creator of the movie poster admitted that he used the New Yorker cover as inspiration. So the courts then turned to the question of substantial similarity. And the substantial similarity question is whether an average observer would recognize the copy as having been appropriated from the original work. And in this case, the courts ruled that this was copyright infringement because it looks as though the Moscow on the Hudson poster was actually appropriated from the New Yorker cover. And right now I'm looking at it and I'm even noticing that the word Hudson and river is pretty much in the same exact font. You'll be able to see now how the actual line between what's an idea and what's an expression is very, very blurry, and it keeps copyright attorneys very busy. Okay, so let's continue on. Derivative works and the copyright accorded to them is very important. Circular 14 is a good one to actually have printed. It gives an overview of what a derivative work is, who can create one, and the copyright that the new work qualifies for. A derivative work is created from a work that's already created. The new work has to add a substantial amount of new material. For example, if I wrote a screenplay based on a novel I'd written, the screenplay would be able to be copyrighted on its own. Someone else, however, could not write the screenplay based on my novel unless I gave them permission. Remember, copyright owners can grant permissions, and I could grant somebody permission to create the screenplay. Okay. The parts of the work that are new are eligible for copyright on its own, but the rest of the parts aren't. Okay. However, using parts of somebody else's work and transforming it into something else may be considered fair use. Fair use is extremely complicated. We'll go over that in Unit 3. But just know to wholesale use somebody's work to create a derivative work. If you do not have the copyright permission, it is infringement. Then there's compilations. Okay. Compilations are when you take things that are already published and put them together into a work. Okay, they might be copyrightable if the materials are selected, coordinated, and arranged in such a way that the resulting work as a whole constitutes a new work. If the compilation is purely mechanical, like we talked about the White Pages phone directory, copyright protection is not available. okay? Um, because the selection and arrangement are considered creative, it would qualify for copyright protection. However, doing this without getting the permission of the individual copyright holders, as like for songs, would be bordering on infringement. There's a very, very narrow band of works that are compilations. Just know that if you do not own copyright for the individual components, you would be wise not to compile them without the owner's permission, unless it's an item that's in the public domain. So, for example, if I gather the best of the best, I take all of the good top restaurant critics and their selection for the best restaurants in Los Angeles, and I compile them together, okay, I would need to have their permission, the permission of the critic who wrote the original article, if I am appropriating something into my work, unless it is something that would be considered fair use, which we will talk about shortly, okay? But at this point, just know that it's to err on the side of caution and get permission. Okay, so what happens if a derivative work is created for something that's already in the public domain? Okay. For example, Romeo and Juliet. The story is in the public domain. That means that anybody can publish that story. Okay. Now, they're going to still attribute the authorship of it to Shakespeare, okay, but they can print the copy, sell the copies, make money on the copies, okay, right? If you create derivative works from works in the public domain, okay, for example, maybe I do a compilation of Shakespeare's plays. I take 3 of his plays, I put them in a book. Clearly, everything in Shakespeare is already in the public domain. I put them in a book and I sell it. Okay, that's okay because the original works are in the public domain, so I am allowed to do that. However, okay, this does not extend the copyright protection for those works. For example, if I take Romeo and Juliet and print it in a new edition and give my own little foreword or explain what the terms are, etc., the things that I created, the things that I added to the story are subject to get their own copyright protection, beginning the day I create it, okay? However, the only thing copyrighted in that book would be the things that I created. You cannot take something from the public domain, add something, subtract something, and get a new copyright and continue to run the clock on it, okay? Also, if you are using something that is in the public domain, okay, it doesn't prevent anybody else in the world from using the same portion. That's why there's 40 different editions of Romeo and Juliet. Okay, Public Domain Sherpa, that website is really helpful for understanding derivative works and what parts of them get their own copyright. Understand that that only applies to derivative works of things in the public domain. Okay, so let's continue on. Okay, first sale. You purchase a book and you want to sell it to somebody else. Because of the first sale doctrine, you're able to resell copyrighted things that you purchased. You can't, however, duplicate the item and sell it or give it away also. Okay, so once you buy something from the copyright owner, okay, it is yours to do whatever you want with. So if I buy my copy of Eat, Pray, Love, okay, from the bookstore, I can use it as a doorstop. I can use it as firewood. I can give it to my friend to read. I can sell it on eBay. Okay, I can do all of those things because of the doctrine of first sale. However, some things don't work that way. For example, What if the book is not a paper printed book, it's an ebook? This is where the complications begin. Some things are not sold, but they're licensed. Okay, we talked a little bit about that before. We're going to talk more on Unit 5. So, if you purchase something and you are not purchasing the object, you are purchasing a license to use the item, you cannot re-gift, resell it. The doctrine of first sale does not apply because you were not sold the item, you were sold the right to use the item under specific conditions for a specific length of time, etc. Okay, so make sure you read the reading on the first sale doctrine. Okay, but we will be talking about licensing a little bit later, as I mentioned. So one of the things that is definitely not sold, but is licensed as software, and you'll notice the license agreement, those come up and you scroll through them and there's like 40 pages of fine print, and you can't use the software unless you click accept. That's called a click-through transaction. By clicking I accept, okay, you are agreeing to the terms in that 48-page document. Okay, and if you read the fine print, you will see what you are allowed to do with that copy and what you are not allowed to do with the copy. Okay, if you do not agree to those terms, you don't get to use the software. Okay, so it's like renting a house. Okay, you have the use of the house for a specific period of time. Okay, but then it reverts back to the owner of the copyright. Okay. At this point, you should be understanding that there are so many complexities of copyright law and there's many gray areas. Please continue to understand that this is how the law is. And the courts play an important role in determining whether or not things are infringement or things are not infringement. So we will look at that in more detail in the coming weeks, but please make sure to read the readings for this week because they provide a lot more clarity and detail than I did. And of course, if you have any questions, post the question in hallway discussions and I will attempt to answer it even though I'm not a copyright attorney. Okay? All right. Thank you.